Oh, it's recording? Okay, so we did ours on the Fourth Amendment and its protections over technology. So just the general history of the Fourth Amendment, it was ratified with the Bill of Rights in 1791, and it was meant to protect the right of the people from unreasonable searches and seizures, as well as issuing the requirements for the issuing of warrants. And it was adopted because of the writs of assistance and general warrants that were abused by the British, which gave them broad power to basically rummage through people's homes in an unrestrained search for evidence.
So the first Supreme Court case that kind of leads into, it set the precedent for the following Supreme Court cases that Jack and I mainly focus on, was Katz versus United States in 1967. Basically, Charles Katz was suspected of transmitting illegal gambling information through the phone to out-of-state, companies and stuff. And so the police were suspecting him, so they wiretapped the phone booth he was using because he was using a consistent phone booth. And so they wiretapped him, and then they wiretapped, and then they went to court for it basically. And so the question presented for the Supreme Court was, does the Fourth Amendment protection against unreasonable searches and seizures require the police to obtain a search warrant in order to wiretap a public payphone? And so basically the government argued that they did not physically intrude the phone booth, therefore they were not violating his amendment rights, but the court ended up siding with Katz, saying that the Fourth Amendment protects people, not places, therefore the fact that they didn't enter the phone booth was irrelevant. And so basically Justice John Marshall Hall introduced the first idea of having a reasonable expectation with the Fourth Amendment, which is really important because that'll lead into our the following court cases. But yeah, this was kind of the beginning. And then the main court case I wanted to speak about was United States versus Jones. It was in 2012, so this is recent. Basically, Anthony Jones was suspected of drug trafficking, and the police, since he was a suspect, they attached a GPS to his car without a warrant, and they watched him for 28 days where he was going. And he was arrested on an 8-count indictment and was sentenced to life in prison for this. And so it ended up going through the D.C. Court of Appeals and all the way to the Supreme Court, and the question presented was whether the warrantless use of tracking devices on a respondent's vehicle to monitor its movements on public streets violated the Fourth Amendment. And so the government is basically arguing that in a public area, a person does not have any privacy, and the government was like, yeah, we can do whatever we want because they're using public space. But the Supreme Court decided that just the physical placement of a GPS on this guy's car without a warrant was completely a violation of his Fourth Amendment rights, and since they didn't have a warrant to do so, it was, yeah.
Okay, so the case I want to talk about is Carpenter versus United States. So the background is Timothy Carpenter was involved in organizing a series of robberies with 15 other accomplices that targeted T-Mobile and Radio Shack stores. Then in 2011, 4 of his accomplices were arrested, and one of them provided investigators with the phone numbers of the other people involved. So investigators use the Stored Communications Act, which allows authorities to obtain telecommunication records so long as there are specific and articulable facts that show it is necessary to an ongoing criminal investigation. But to obtain the records, you don't actually need a warrant. So they used this evidence against Carpenter, and he was convicted and sentenced to a total of 116 years in prison. Then so Carpenter appealed his conviction, stating that he wanted to suppress the government's evidence, saying how it had been obtained without a warrant and it violated his Fourth Amendment rights. So the district court sided with the government. Then he appealed to the Sixth Circuit Court of Appeals, who also affirmed the lower court's ruling, stating that since Carpenter had voluntarily shared his cell phone location with his wireless carrier, he lacked a reasonable expectation of privacy. So the question presented in this case is whether the gathering of that person's cell site records constitutes a search under the Fourth Amendment. So the Supreme Court was divided in the decision. It was a 5-4 decision. The majority sided with Carpenter. They stated that since so basically, so they acknowledge that the Fourth Amendment does not only protect property interests, but also the reasonable expectation of privacy, as had been acknowledged in Katz. They mentioned that prior precedent really doesn't mention digital privacy too much, but they stated that they believe prior precedent would have sided with them, since the expectation that the government could obtain all your location records on your phone was definitely outside the realm of what they could have imagined. The court also rejected the claim that since the cell phone location had been shared with a third party, such that being Carpenter's wireless carrier, I believe it was Sprint in this case, that he no longer lacked a reasonable expectation of privacy. They basically stated that since cell phones are such a pervasive part of modern life, and that they are constantly tracking our location without our consent, the information was provided to his wireless carrier largely without, not voluntarily. And it also limited the power of the third-party doctrine, which states that any information you provide to a third party, you no longer have any reasonable expectation of privacy. And yeah, that's it. Any questions? Awesome.
Was he released because of it?
I don't know. He was convicted. He was not only convicted on the robberies, it was also firearms charges they got him on.
Yeah. And so for our creative piece, we decided to make a poster. I'll get out of the way. There were some artistic choices made, so we decided to make it look like the Supreme Court. And then with that, we had all our two cases and kind of the most important information that we learned from studying this in the Fourth Amendment. And yeah, feel free to look at it whenever you want.
Any other questions? Serena?
Based on these decisions, what trends do you expect to see in the future as technology advances in the Supreme Court?
Well, the decision in this case was definitely very narrow. They didn't really want to expand the third-party doctrine too much, so those records are still available to the government.
For the future, I think it's really important that we keep this precedent of reasonable expectation that Justice John Marshall Hall created, as I think it almost adds a layer of humanity to decision making and having mercy, and not just because sometimes I feel like when we follow the Constitution, it's too we forget that they're people also. So I think within reason we can expect to have more legislation.
Yeah, and the fact that they just recognize that technology is just such a big part of life now that you expect it to be private.
Exactly.
Anyone?
Do you have any questions?
Yeah, no, I'm just interested in, given all your study of this, how has it changed what you think about, there's sort of bad actors using technology?
Definitely. And
how you think about that balance, because they're protected and yet they're using technology in really nefarious ways.
I think it's going to happen. It's bound to happen. Just like guns, just like with drugs. I think people are always going to be doing bad things. So I don't think technology is any different. I think as long as the laws protect the majority of the common people, and there's always going to be the extraneous cases of malintention.
And does this make you all think any differently about your use of cell phones, or what's on your phone, or does it make you consider your life with your phone?
Maybe not so much these cases, but just becoming more cognizant of the fact that I have a tracking device in my pocket all the time, so.
Theoretically.
Yeah.
So if they got a warrant, they can find you.
Exactly.
Yeah.
I don't know, something to think about.
Yeah, in Carpenter's case, I forgot to mention how they use these digital points. So basically, they collected over a 127-day period, and were able to find that he was in proximity to all the sites of the robberies around the time that they were committed. And they just obtained that without a warrant.
So I guess it's good they're protecting our rights. It just does point out the power of technology today and the dangers that they're in. Okay, round of applause. Good job. Great. So, do you want a break? It sounds like you want a break.
Yeah. Oh, we got to turn this off.